What are we doing on this case?
Good morning, everybody. Welcome to the Courtroom Files Live. A little rough transition there. Apologies. But we're going to start our day with Judge Simpson.
People have their witnesses available to 10.
Yeah, we will do our best.
Preliminary examination in person will be set June 10th, 2025, 9 a.m. before Judge Barr. Bond will continue. Thank you. Court does call the case of the people or cases of the people versus Shanoa Harris.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Edward Dukas on behalf of Shanoa Harris.
Harris. Hi.
Thank you, Your Honor. I'm still obtaining some discovery in this matter. I'm asking for an adjournment.
All right. Today's 29. Probable cause conference will be adjourned to June 12th, 2025, 9 a.m. Yes, Esteban.
Your Honor, it's come to my attention, the defendant has been contacting the victim through jail calls. One call specifically has caused concern. She asked her to get a PO box that she can send mail to. I have concerns for her well-being, as well as the defendant violating her bond. So I'd ask that her phone privileges be revoked, as well as her mail privileges.
Response.
Your Honor, I haven't heard any of the phone calls. I'd like to obtain those prior to making any decision.
The issue with the mail, certainly we will let the jail know. The revocation of that becomes somewhat of an issue, but they do have a way of figuring that out. But at this time, what I will do, and certainly, Mr. Drukas, you can request a hearing. I'm going to grant the people's motion. Defendant's phone privileges shall be revoked. Pending a hearing. Thank you. 12.
Thank you.
Thank you. That's called the case of the people versus Andrew Patton. It's just that case.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Christina Costantino, on behalf of Mr. Patton.
Where is he?
Unfortunately, Judge, his whereabouts are unknown at this point. I know there was some confusion as to.
Oh, I had no confusion. I don't know.
I'm sure you.
I don't know who else decided they had some confusion, but I had no confusion. He is supposed to be my guest at the Washington County Jail, and he is not.
You can take the approach on this matter.
All right, well, he's muted. Let's head a little bit southwest of him to Judge Anzalone, who is doing sentencings this morning.
Versus Christina Mia Edmonds, file number 24-21983H. I have Brenda Underwood appearing on behalf of Miss Edmonds and my PO on this. This is Jennifer Walsh, who is appearing via Zoom. So, Miss Edmonds, have you had a chance to read the probation violation recommendation?
Yes.
Have you had an opportunity to discuss that with your attorney?
Yes.
Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yes.
All right, are you picking her up? She's soft spoken.
She's very soft. She's got it, yeah.
Yeah, just a little bit louder for me. All right, Miss Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the?
I don't believe we do.
That's important. All right. Before the court passes sentence, is there anything you'd like to say on behalf of her?
A lot.
Yeah.
I believe that Ms. Edmonds has had a long road here. And Ms. Walsh has had a long road with this Edmonds. I talked to Ms. Edmonds, and in going through this whole thing, Your Honor, she never quite put together the fact that the problem here, which was masked by the drug problem, is a significant alcohol problem. I think it's significant to note that Ms. Edmonds, on her own, Your Honor, wrote a statement she would like to make today that I've read, and she also has a certificate of work she has put in at the jail as far as classes, Your Honor, and I would like the court to take notice of that. But I think Ms. Edmonds understands her problem, Your Honor. I think I understand the 15-day recommendation. I think that's appropriate for a first violation, as this is. And the only thing I would say, as far as the contempt, Your Honor, is I don't recall seeing a recommendation for contempt in a violation before, but I would hope the court would consider very much giving Ms. Edmonds time served on the contempt. Your Honor. With that, I believe Ms. Edmonds has something she would like to address the court.
So Ms. Walsh, we had a violation of probation, request and warrant for probation violation on May 12th. And Ms. Adams, I believe this is the one Ms. Adams left me a note on. We didn't have a contempt of court in the file.
There should, I'm not sure how that would work. It was the bond condition. She did violate a bond condition. The scram was a bond condition given by Judge Olsaver.
Ms. Adams, is that the one we couldn't find paperwork for it? Like there was no contempt of court filed?
Yeah, I think so.
So she did violate bond conditions, but because it was done by Judge Olsaver, I think we probably screwed that up by not, there's no contempt of court to sentence her on because she wasn't, there was no paperwork done. So I'm sorry, Ms. Walsh, on that one. Okay. All right, anything, you have something you want to read for me?
Yes, I want to admit for tampering and drinking with the scram. And I'm somebody gonna cry, but I never really looked at my alcohol. That was a problem, but me being in jail, and taking like a self-inventory, like every time I did get picked up by the police, it was due to alcohol. So I've never really, like, I've been in denial with alcohol. With my crack addiction, I've been clean off crack since August of last year. But I truly can say that I've been in denial of my alcohol use. And like, I've caught cases with alcohol, but the charges always get dropped because it's with my family. So I know I do need to get my alcohol. I need to go and get in meetings and take care of this alcohol problem. And I just always been in denial. But I know I know I do have a problem. When I drink, I do abuse it and I abuse others. So I know. Since I've been in there, I've been, coming to it that, yes, I do. With my alcohol. And like I said, when I got that scram, I reached out to CMH in Monroe. They gave me access to get services, to get into Catholic charities that I'm willing to do in terms of outpatient. I just got housing.
What about inpatient?
I can do inpatient, it doesn't matter. But I just got housing. I've been homeless since 2023. And I got housing now. I need to pay rent. So if I get out of treatment, I need a place. I have a place already. I just don't want to lose what I got now.
And is that in Monroe?
Yes, it's in Monroe. And then I got everything set up through CMH in Monroe, so. And I'm willing to do anything. I take the breathalyzers every day or whatever it takes. Then I completed a course online, the subsidies course. So, yes. Trying.
Okay. All right, anything else, Ms. Underwood?
Thank you, Christina. With that being said, Your Honor, I believe she served 22 days, and the recommendation is
And Miss Walsh, was her probation transferred to Monroe?
It was, but it's back here. It has to be re-transferred again, and all of that, so. That will take time.
So Miss Edmonds, yes, I mean, you're what, you're 53 now? Right?
Yeah, I thought I was 54.
You might be 54, but my paperwork says 53. So, you know, Miss Edmonds, I'm a little bit older than you, but I mean, I can't do the stuff I used to do. I can't imagine you can still keep this up. And you're right. You have always had a substance abuse issue and an underlying alcohol problem. I mean, I've known you at least 20 years. And, you know, but for these things, you never get in trouble. So, Ms. Edmonds, your guidelines originally on the underlying offense were 0 to 11. So I can give you up to a year in jail. But, you know, one, I'm hurting that for the first time you're telling me you have an alcohol problem, because I have not heard that before from you, but it's my hope that you will do something about it now. So we're gonna give you one more, you know, we're gonna give you another chance. I'm gonna continue your probation. You know, the terms of your probation, there's no alcohol, there's no illegal controlled substances. Upon your release, I want you to do 90 and 90 meetings. All right, you'll have to do the paperwork to transfer probation to Monroe. I want you to have an assessment. You said you've already contacted CMH. I want you to complete all programming recommended. So inpatient, outpatient, whatever they recommend. And if you, so the scram, is that through a bond condition on her new charge, Ms. Walsh?
Yes, but we placed it on her, MDOC did.
Okay. All right. Do you want it as a term of your probation or is her bond conditions on the new charge?
Bond condition on the new charge as of now, for now.
Okay. You are to comply with all bond conditions on your OWI charge. So if they put a scram on you and you alter it again, because you don't have it now, right?
No.
If you alter it again or try to mess with it, then that would be a violation of probation. You understand? Okay.
Judge, this time I would ask that it goes through the bond agency instead of us. She got a break last time. And I would like that placed on her before she gets out of jail.
How is that a break? Because I'm asking because I don't know.
I believe it may be a few dollars cheaper, but I mean, she had the means to violate by consuming alcohol while on it.
Don't you get disability? Yeah, I'm gonna order it as, I don't think she has the money to do that, and that's just setting her up for failure. She's on disability, so I'm gonna order it as a bond or as a term of probation. So does that mean she has to come here today?
Yes.
Okay. So I'll give you credit for time served of 15 days. When you get out of the jail, you need to come back here and get that scram on. Miss Edmonds, you know, you were out, what, 8 days before you got arrested? It'll happen again if you don't get this under control. And the next time you could be looking at a bigger felon. All right, do you have any questions? So I'm gonna, anything else you want me to add, Miss Walsh?
No, Miss Edmonds, you need to come immediately to my office, nowhere else.
I will. What time are you gone for lunch, Miss Walsh?
We close from 12 to 1.
So 12 to 1 is lunchtime, but if you get out before 12, come directly here. If you get out during the lunch hour, come here right at 1. All right?
I will.
All right, you do have the right to appeal this sentence, and my bailiff's gonna hand down to your notice of right to appellate review. Sign 1 copy for our records. Okay, so you're gonna get 3 copies of your notice of right to appellate review. You're gonna sign 1 copy for our records, the other copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right? You're welcome. Miss Edmonds' variety looks good on you. You know, you're clear, you look at peace. So keep up the good work, all right? Thank you. Record should reflect, I received back a signed copy of the notice of right to appellate review.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live, now with refreshed branding. Let me know what you think in the comments about our new look. Vicky, if you are out there, I realize in today's pre-show that I forgot to show the photos of your dog that you sent us. We will lead with that in tomorrow's pre-show. I apologize. I had them queued up and just totally slipped my mind. Let's go back to Judge Simpson.
Guess it depends on who they are. But
I was going to take a stray from somewhere today, Judge, so it's okay.
My foot ankle's going up and I can't walk on it.
Okay.
all right, go ahead, counsel.
Good morning, ladies first.
Good morning, Your Honor. Assistant Public Defender Chinazi Carey Akinruli on behalf of Mr. Rick Artuzo on the 0436 matter, Judge.
And good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuzo as to the remaining matters, Your Honor.
All right. What are we doing?
Your Honor, we were just going to set this for exam. The people have extended an offer, but it requires a substantial amount of restitution. Clients in custody is just not really able to do that. So we're just going to set it for exam. I believe
We're doing that on our matter as well, Judge.
All right. So all discovery is complete.
That's correct.
People have their witnesses available to 10.
Yes, Your Honor.
Preliminary examination in person, June 10th, 2025, 9 a.m. That is before Judge Valvo in both matters. Bond will continue.
Thank you.
Thank you. Court does call the case of the people versus Christy Couch.
Children's attorney on behalf of the people.
Once the traffic clears, Your Honor, David I. Goldstein appearing on behalf of the defendant.
Your name, ma'am?
Christy Couch.
All right. What are we doing on this case?
Your Honor, there are 3 co-defendants. They're all set for PCC on the 12th of June. So I think Mr. Childers and I are simply going to ask this matter be adjourned over to that date.
Probable cause conference without objection, June 12th.
Thank you, Your Honor.
Thank you. Case of the people versus Danya Boone.
Allie Zen on behalf of the people, Your Honor.
Yes, good morning, Your Honor. Robin, on behalf of Danya Boone.
Your name, ma'am?
Danya Boone.
Thank you. All right, what are we doing on this?
I am not aware of any offers at this time. We would like to address the bond, and they have a 2-year-old child in common, so the parenting time exchanges as well.
Going to get it all into that. I'm trying to figure out what to do with this case today. Are we going to set it for exam, or what are we doing?
If there's no offer, yes, we would set it for an exam, Your Honor.
And I did just want to put on the record, we requested the 911 call yesterday, have not received it yet, so it's not in the file.
Okay. So the 911 call is the only thing outstanding?
I believe so.
Yeah. People, other witnesses available the 10th?
We'll do our best, Your Honor.
All right. Preliminary examination in person will be set June 10th, 2025, 9 a.m. before Judge Barr. As to
Okay,
bond,
and Your Honor, will that, I just want to be clear, it'll be Judge Barr, will that be on the Hogback location or will it be at, it'll
it's
be?
at the service center. All
Service-
exams are at the service center.
Okay, that's, okay. And then
As to bond,
so my client is 39 years old. She's been a bus driver for 15 years at the Lincoln Consolidated Schools, no prior record. The parties have a 2-year-old child in common. And so, as my understanding, this is an isolated situation. Nothing like this has ever happened before. They do have, there's a, she's collecting child support from the complainant. And so we're requesting that she have a PR bond. We would want to see if they can have contact, I guess, via app close, and have the parenting time exchanges at the Ypsilanti Police Station on Michigan Avenue, where it's my understanding, the complainant lives by that location, and that, as my understanding, that the stepdad could do. Mr. Maurice Davis has agreed to do the exchanges. The child right now is with the maternal grandparents.
respond.
I would object to any change of bond. This case is extremely serious. It involves her stabbing the victim in the chest. He was found laying on the couch, bleeding profusely. He had lacerations to his hands, his forearms, his shoulder, a puncture wound to his chest. At the time she was arraigned, he was unconscious in the ICU. I have not heard anything from the victim regarding contact, and I would object to any change in the conditions of the bond and ask that it remain as said.
And Your Honor, if I could just briefly respond, my understanding is that there was a party, there was drinking involved, there were several people there, and that the complainant was not clear on who stabbed him. I don't know, I wasn't there. But my client has had nothing. She's never had anything like this before. It has been gainfully employed as a bus driver for Lincoln Consolidated Schools, which my understanding is that she would have that option to go back to school to support herself and her child. If she's incarcerated, she won't be able to do that. And the child is in the care of the maternal grandparents. And I don't, I think dad is paying like a small amount of support. So, yeah.
There were witnesses at this party who saw the defendant with the knife in her hands after the victim was stabbed.
Motion for bond reduction is denied. Bond will continue. Thank you.
Could we have have a referral over for pretrial services for an evaluation on bond, or?
I don't care what you do. I just listened to the argument on bond. Her bond, and I don't know who you'd send it to. Ms. McCoy, if you want it sent to somebody, you figure out who it's going to be sent to. Her bond was set before the magistrate. The magistrate did their assessment of it. I've listened to your argument. Bond is denied. Bond will remain at $500,000 cash surety. Thank you.
All right, thank you, Your Honor. Oh, wait, Your Honor, what about, so she's incarcerated, but the child is with the maternal grandparents. Can we have it where they just have the parenting time exchanges with the stepdad at the Ypsilanti Police Station for dad to be able to see his son?
I am not doing that.
Okay.
Thank you.
Thank you, Your Honor.
Court calls case, People of the State of Michigan versus Fall Ali. Madam AGA, if you state your appearance, please.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Where's Bekovich?
Michael Gaddy, Assistant Public Defender for the defendant here.
Mr. Ali, can you state your name, please?
This is for Al Ali.
Thank you. What are we doing on this case?
Yes, Assistant Public Defender Nicholas Bukovich on behalf of Mr. Ali, who will be requesting a 2-week adjournment to obtain some additional discovery.
Any objection from the people?
Yes, Your Honor, it is an objection. I thought we just spoke about this
Okay.
case.
We spoke about Mr. Amerson, not Mr. Ali. Mr. Ali was the one who I asked for the additional discovery on. I have 2 cases up with you this morning.
Right, and I object to the adjournment because I sent him the information in terms of what we're offering, and I just think a decision at this point needs to be made in terms of what's going on, but I don't know what he means by additional discovery, so I'll leave it to discretion.
I don't either. So what other stuff are you looking for?
My client would like a full accounting of the matter.
The what?
A full accounting.
So a full accounting of the child support?
Yes.
So if he went down to the FOC, he could get that at any time, quite frankly.
Understood, Your Honor.
So if I don't grant the adjournment, what are we going to do? You want it set for exam? Are you ready to go?
Could we pass this matter so I have a moment to speak with my client?
Madam AG, you have another case, right?
Yes, I have 4 more with you, Your Honor.
4 more? Okay. I'll pass it. And court
Thank
does
you.
call the case, People versus Damon Bransford.
Good morning, Your Honor. Christina Barragarian requesting permission to practice pursuant to Michigan Court Rule 8.120 under supervision of Assistant Prosecuting Attorney Ashley Long.
You're under her supervision?
Yes, Your Honor.
Are you? How's that going?
It's going well, Your Honor.
Is it?
Yes. Yes, Your Honor.
Was Londi?
Yes.
Really? She must be nice not to know anything. Okay. I'm kidding. Permission to practice is granted.
Thank you, Your Honor. Christina Barragarian.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bransford.
Where is he?
Yes, he's on Zoom, sir.
Sir, state your name. There he is. Hang on.
Come on, Bransford.
Thank you.
We'll be seeking a 2-week adjournment for negotiations. Mr. Bransford, I'll be coming to speak to you soon. The prosecutor rejected my proposition, so.
Probable cause conference will be adjourned without objection, June 12th, 2025, 9 a.m. Bond continued. Thank you. Let's call the case People versus Rafael de la Cruz.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning, Your Honor. Kelma Dadish on behalf of Mr. De La Cruz. Is he on the Zoom?
I do not. Mr. De La Cruz, you have him?
I thought it was at 12:30.
What?
I believe the Zoom link that I received said it was at 12:30.
It shouldn't have.
So I told him
It's
to
an
here at
AG
12:30.
case, but
He's not gonna have
he's
signed
on the
in.
cheat sheet for 9 a.m.
Your Honor, can we go off the record and approach, please?
Well, I can't because I got her in Zoom.
Can we pass the matter, Your Honor?
I'll pass it. Right. Court does call the case People versus Devasere Hennings.
APA Rachel McDuffie for the people.
Good morning, Your Honor. Christina Castellano appearing with and on behalf of Mr. Henning. Mr. Henning, can you state your name for the record?
Vassier Henning.
Thank you. What are we doing?
This is a matter that we just adjourned for the co-defendant a little while ago out to.
I think it was June
Wow.
12th.
Probable cause conference adjourned June 12th, 2025, 9 a.m. Bond continued.
Thank you, Judge. And just for the record, my understanding is that there still is outstanding discovery, and that's the reason for the adjournment.
Yes.
Thank you.
Thank you. All right, we got
Let's move down the road a little bit and say good morning to Judge McNally.
This will be dismissed, correct?
That's correct, Judge.
That charge impeding traffic, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the original charge, 235, and I'm gonna give them until June the 13th, okay?
Good to see you, Judge. You're a YouTube sensation. I've been watching some of your videos.
You know, a friend of mine, his name is Ron Muir, he's from Florida. He's very good friend. And he bugs me to get on there, bugs me, calls me up afterward. Boy, that was so, jeez. I don't know, he likes watching, he's retired. He doesn't have enough to do, I don't think. He's a good man,
Yeah,
he's a good friend, so.
You probably got at least 10 of them out there.
What's that?
You've probably got at least 10.
Oh, geez, well, good to see you, Mr. McDermott. Take care.
You too.
Bye
Take
now.
care, Judge.
All right. So we have Chavis. Abro Lachey Chavis. 25B1474001B. You know, if you guys are on this side of the courtroom, I'm just telling you, if it's easier, you can walk up this way. If you're on this side or over on the right, your left side of that middle, the biggest row there, you can come up through these doors. Your name, ma'am? You're charged with failure to pay fines and costs of $225. If you plead guilty, or if you're found guilty, you have no prior technical violations, you could get 5 days. Do you understand that? Did you sign the advice of rights and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? All right. Okay. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
Sure.
You have the money.
Not today.
How much do you have today?
I can probably pay 50 today.
All right, okay. If you want a lawyer, I'm gonna give you a lawyer. Hang on, just listen. Just listen. If you want a lawyer, I'm gonna give you a lawyer. If you don't want a lawyer, I'm gonna set up a payment. But you understand that? I'll set up a payment plan with you, but you were supposed to pay that day. Why didn't you pay that day?
I honestly was pressed for time and I had thought about, coming back to pay it, but because I had to be at work by a certain time. And I honestly forgot about that. I forgot. So my work schedule was crazy. I work 7 to 4.
Where do you work?
I work for Corwell and Dearborn at the Cardiovascular Center. I work 7 to 4:30, so I was pressed.
I know, but you can't just walk out of the courthouse when you're telling the judge you can pay that day, right? You can't do that. All right, you have $50 now?
Yeah.
I'll dismiss the show cause, but don't do this again, okay?
Okay.
If you didn't have time, you should have told me. If you didn't have time and had to leave, under no circumstance should you have done that without saying, can I pay tomorrow? You should come in the next day. You can't do this, okay? All right. You pay 50 today, when can you pay the balance?
Can I have it paid by my next court date, the 18th of June?
You have a court date?
Yep, June 18th.
With who? What's that
I believe for probation.
on? Oh, geez, you want to get this case you want to get this dismissed?
Oh, so the sooner I pay it, it gets.
Well, no, you got to come in the 18th. You pay by what day of the week is the 17th? Should be, let me see here.
It's a Tuesday.
You pay by the 17th, okay? You pay 50 today and the balance by June the 17th. And then you're coming in here on the 18th, and if everything's in order, you're gonna have your case dismissed, okay?
Okay, could I pay online?
Yeah, you can pay online.
Okay, this is my job now, y'all 2 days in a row.
Well, you don't have to, you can pay online.
Okay,
You go down the hall, pay your 50 now.
okay,
After that, you pay by the 17th. And there's no charge for it.
okay,
Just pay the balance, okay?
okay.
Don't do this again. Good luck.
I won't.
You got too good of a job. You're too smart to do this. Frank DeMar III. Have a good day.
Thank you.
25W838-508. How you doing?
In court, I'm doing fantastic.
What's that?
So I'm in court, I'm doing fantastic.
Why, you like coming to court?
I love it.
You're gonna plead to impeding, right?
Correct.
To that charge, responsible or not responsible?
Responsible.
Original charge of distract is dismissed. I'll accept your plea to impeding. 150, you're all set.
Thank you, Judge.
Have a good day. Carrie Elizabeth Chaffins, 25W838-626. Could I have seated at the table Amber Manley? Jacob McIntosh. Your name, ma'am?
Carrie Schaefer's.
Okay, so you're just gonna plead to impeding, right?
Yes.
Okay, they just warned you on the speed. You gotta,
Yeah, I kind of meant to make a payment plan online and I must have set up a court date, not paying attention to what I did
that's all right.
online.
To the charge impeding traffic, responsible or
Yes,
not responsible? Why you driving so fast?
Honestly, I was a bad day and I was.
Why was it
Bad day. I
bad?
left my husband that day. We
Oh, no,
separated.
jeez.
I just kind of
All
was.
right, you don't need to tell me. 150 is your total.
All right, thank you.
And you accept, and you're pleading to impeding, correct? All right, go down the hall, take care of that, and you're all set.
Thank you.
And you have the money?
No, I don't.
What do you
It was
have?
supposed to be set up as a payment plan.
What do you have today?
I don't have nothing today. I get paid on the, what is today actually?
This is the 29th,
I get paid
Thursday.
on the 7th.
Okay.
Come back in on the 7th.
So let's see, the 7th is a Saturday, so you pay
So
by
I'll come in-
June the 9th.
Yep.
Pay by June the 9th, 150. If you need more time, you don't have the money, come in, talk to me on or before the due date or call, and we'll go on Zoom, and I'll be happy to give that to you, okay?
Okay, thank
Good
you.
luck, Ms. Jacobs. Amber Manley. Amber Karen Manley, 25F243774. Where's Jacob McIntosh at? Your name?
Amber Manley?
All right. Is there a Jacob McIntosh?
Judge, he had two cases and he came down to the window. We thought they were both addressed. So he's on his way back.
Oh, okay. Ms. Manley, I'm sorry, tell me your name again.
Amber Manley.
You gotta slow down and be careful here, okay?
Yeah, guy swerved at me, and then I took off kind of fast.
The Jew,
I should have probably slowed down, so yeah, I did.
you gotta slow down and be careful.
Yeah, well, the man, black truck swerved at me, I'm driving a little 08 Honda, and
The charge impeding, responsible or not responsible?
responsible.
All right, I'll accept the plea. 175, speeds dismissed, cashier under the hall to your right. Good luck. McIntosh, Jacob Gregory McIntosh. 25F243923. How you doing there, Mr. McIntosh? Your name?
Jacob McIntosh.
Okay. You're going to plead as charged to impeding, right? Responsible or not responsible for that charge? Pardon? I'll accept the plea. 150 is your total. Cashier into the hall to your right. Good luck. Keith Bradley McKeel, 25T645318. Good morning. How are you? Your name?
Keith McNally.
Was there serious damage to the other vehicle?
Wasn't too bad, I was only doing 20 miles an hour when it got brakes give out.
The brakes gave out?
Yeah, I was lied to by my truck boss, which they've since fired, so that the truck was serviced and it never was.
He just wrote no injuries. You were going 20.
Yes, sir.
To that charge of impeding, responsible or not responsible?
Responsible.
270 is your total. Cashier into the hall to your right. Good luck. Yisu, Ricardo Michael Yisu, 25T645528. Your name?
Ricardo, yes.
So how'd you manage to strike a pole?
I passed out when I was driving, trying to get to the hospital to see my daughter.
Was she okay, I hope?
Yes.
Good. All right, I'm glad for that. All right, so you're gonna plead to impeding, right?
Yes, please.
Responsible or not responsible to that?
Responsible.
All right. $200 cash your end of the hall to your right. Best of luck.
Thank you.
Zakaria Muna. 25T645285. Yeah. Minor injury to defendant, major damage to defendant vehicle. I'm assuming. Your name? So nobody was hurt in the other car? I can't hear you. Was anybody hurt in the other car?
With my car, no.
Okay. Have a seat 1 second. We're gonna have to get Lieutenant Greeno in here. Have a seat right there. There you go. Ernest Philip Stewart. 25B148541. Good morning. Your name? Name?
Ernest Stewart.
You're going to plead to impeding, right?
Yes.
Responsible or not responsible to impeding traffic. Please accepted. 160 is your total. Cash your end of the hall to your right. You're all set. Good luck.
All right, I have a question. By being the first of the month, can I make some kind of payment arrangement?
Yeah, when can you pay this? June 5th?
I'll pay half today, and then 2 weeks the other half.
Okay. You pay, so you got 160, you pay 80 now.
Yes.
Balance by, we'll just make it June the 12th. Okay?
All right, great.
Best of luck. If you need more time somehow, come in here and talk to me, okay?
All right.
Good luck. Deborah Jean.
Let's move down the road again. We'll say good morning to Judge Meineke.
Guilt has to be proven beyond a reasonable doubt. Mr. McWilliams, do you understand that once you enter a plea, you give up all those rights that I just said that you have at a trial?
Yes.
You understand that, Mr. Harris?
Yes.
Mr. McWilliams, do you understand that once you enter a plea, there'll be no trial?
Yes.
You understand that, Mr. Harris?
Yes.
All right, has anybody promised you or threatened you in any way other than the reduced charge in order to get you to plea, Mr. McWilliams?
No.
Mr. Harris?
No.
In the end, is it your own choice to enter this plea, Mr. McWilliams
Yes.
and Mr. Harris?
Yes.
All right, Mr. McWilliams, directing your attention to June 1st of last year, 2024, were you in the city of Berkeley?
Yes.
All right, and did you allow an unlicensed person to drive your vehicle, that person being you?
Yes.
And do you plead responsible to careless driving?
Yes.
Okay. Satisfied on that one, Mr. Dean?
Yes, Your Honor, thank you.
I too am satisfied the plea is knowing, voluntary, and accurate. I will accept the same. Monica, for some reason, I do not have a driving record for Mr. McWilliams. Will you print one out for me real quick? And I will, I'll finish taking the plea on Mr. Harris. Mr. Harris, directing your attention to March 31st of this year, 2025. Were you in the city of Berkeley?
Yes.
Did you allow an unlicensed person to drive your vehicle, that person being you?
Yes.
Do you plead responsible to 1 to 5 over?
Yes.
Okay. Satisfied on that one, Mr. Dean?
Yes, Your Honor.
I too am satisfied the plea is knowing, voluntary, and accurate. I will accept the same. All right, so let me start with Mr. Harris while I'm trying to take while I'm trying to get the record for Mr. McWilliams. So Mr. Harris, we're going to put you in a program called Operation Drive. We got to get you your license again, get you back on the road without having to look over your shoulder and be in situations where you have to basically be in a virtual prison, rolling the dice about driving or having to pay for Ubers and things like that. It's just no way to be. So let's take a look here. Okay, so Mr. Harris, here's the way this is gonna go. I think you should be able to get your license probably in the next 45 days. So a couple things. One of the reasons your license is suspended is because out of Royal Oak, you have an old no proof insurance ticket that you haven't taken care of. And once that's taken care of, that'll get us one step closer. Also, the speeding ticket on this one is going to bump you for 30 days because even though you didn't plead to a suspended license, the Secretary of State will look at that and say, all right, he was speeding on that day, so he must have been driving on a suspended license. So I would imagine in the next week, you'll get a notification that says it's suspended for 30 days. So what you'll need to do, Mr. Harris, is use that time. You owe 144 on this no proof of insurance, but of that 144, only $45 of it is going to be what's considered the clearance fee. Now you got to pay all of it at some point, but if I let you pay the first $45, that'll take care of that suspension, and then you can pay off the rest. So I'm going to, on the two charges you just pled to, I'm going to delay all payments for now. All right. So you don't have to worry about that holding you up. I would rather have you take care of the clearance fee on the no proof insurance, pay the 125 fee for reinstating your license when the 30 days are up. And then once you get your license back fully, then I can set fines and costs. I can set them at a lower amount because you have your license, and I can still give you plenty of time to pay. So I'll set this for a review in 60 days. So look in the mail because the Secretary of State will send it to the Illinois address. Is that still good?
Yes.
Okay. So look for the Secretary of State information and then make an appointment with the Secretary of State online for the day after that suspension. Like they'll say, the notice will say your license is suspended as of, June 2nd through July 1st. All right. Well, if that's the case, make appointment with the Secretary of State on July 2nd so that you don't have one more minute suspended. Now, you won't be able to get it until you pay that clearance fee here for that old no proof insurance ticket. All right. So here's the step-by-step for Aaron Harris to get his license, step-by-step, pay $45 to this court. All right. For the no proof insurance ticket. I'll give you a phone number before we leave to call to make sure you get that $45 to the right spot. And then you sit out those 30 days and then immediately go in Secretary of State with 125. You'll get your license back. Hooray. You'll see me. We'll celebrate. I'll reduce your fines and costs on these other two charges you just pled to and give you a time to pay. Does that make sense, Mr. Harris?
Thank you.
Okay. All right. So I allow. All right, so I'll allow you to pay the $45 clearance fee on the insurance ticket. All right, so call this number when you can, Mr. Harris. Do you have a way to write down a phone number?
Yes, I'm in my notes right now.
All right, 248.
Okay.
246. 3675.
3675.
And
Thank you.
You'll call them up and say, hey, I just talked to Judge Meineke. He's putting me in Operation Drive. He says I have an old no proof insurance that I can pay a $45 clearance on. Can you help me?
Okay.
All right. And then that's all you pay for us. And then you save up the 125 for when you go back and renew your Secretary at the Secretary of State. Okay?
Okay.
All right,
Thank
Mr.
you.
Harris, we got a plan. We got this. When I see you, you have a license. Good luck.
Thank you so much.
Thank you, Mr. Harris, for jumping in.
Yep. Thank you.
All right, let's go to Texas. We'll say good morning to Judge Boyd.
Morning, how are you doing?
I'm doing okay. How about you?
Oh, I'm doing all right. So we were here last time, and the reason why we were here is there was a request for the GPS removal.
Yes, Your Honor.
And the court was inclined to do that, but then the court received different information from the state. And I believe the defense had not had an opportunity to review it. So you're here today requesting removal of the GPS, correct?
We are, Judge.
All right, court is calling 2023 CR 7339. State versus Nicholas Corpus. Can I have parties announced?
Ashley Jones for the state. Linda Corley for Mr. Corpus.
Off the record for a moment. So on Avila to the interpreter, as soon as this hearing is concluded, can you give me 5 minutes?
Yes.
All right, thank you. I'll call you up after this. We're back on the record.
Thank you, Judge. My client has been on GPS for an unusual length of time. Part of his probation was that you had ordered him to be on GPS for an indeterminate time. You wanted to see how he did on probation. He's been on for, I think, almost 14 months now.
Excuse me, just 1 second. Guys, we're on the record. Okay, you may continue.
He's been on for almost, I think it's around 14 months now, not counting the time that he was on pretrial. I was given at the last hearing, as you know, some information about alleged attempted contact by my client. This time we're denying all of that. That was back in April of 2024. There's been no warrant issued. I didn't have any information on
So
this.
the alleged contact is from April 2024?
Yes.
Is that correct, State?
Yes.
All right, and so has a case been indicted, a case been brought?
No, Your Honor, it is awaiting filing.
All right, you may proceed.
Judge, other than that, as you know, at the last hearing, probation actually told you that he's been a model probationer. He's not had any problems whatsoever. He's followed all the rules, and obviously it's very extensive. GPS is no small matter. Besides everything else, my client has not attempted to contact the complainant. He has absolutely no interest in that. And we would request that the GPS be removed at this time because he has followed all rules.
All right, State.
And if you'll recall from last time, Your Honor, we had reached out to the complainant to see if she had any safety concerns or how she felt about the GPS being removed. She expressed she did have safety concerns and did not want it removed. I informed the court of such. Additionally, I informed the court of the DPO from June of 2024, and that the victim had expressed to me a friend or a person she knows to be a friend of the defendant had viewed her LinkedIn profile, and so she just didn't know if people were.
So what we have is double hearsay.
Correct, Your Honor.
Maybe triple hearsay.
But on behalf of the complainant, the state did object to the removal of GPS.
All right, so again, the court sees, and of course, I don't make any decisions until cases are brought before me and motions are filed, but there is a legal issue having a case that's been in your office since 2024, and there has been no movement to seek an indictment. It's just out there in the ether. And then you want him to be in limbo on GPS. Probation has informed the court at the previous hearing that there have been no issues with him on GPS, which, counsel, I will note, it's hard to be on GPS and not receive any type of violations. And probation has informed the court that he has not violated GPS. And I had him on specific GPS to begin with. He did well on that. And then the court moved it to tracking only. And then now we're here. And how long has he been on GPS?
Almost 14 months, Judge, since he did his plea.
November 2023.
Yes, so he's been on GPS since November 2023, and he has had no violations. And probation, has he completed everything?
His bed, his top. He's done well with the skill visits. There are no outstanding cases, Judge. No outstanding conditions.
All right. I don't see any reason why GPS should not be removed. If there's a concern, if the state has a concern with the complainant, then And I know it's not your fault, but if the state has a concern with the complainant, then this case should have been moved through whatever process it should have been moved through towards indictment. A grand jury will look at it. Either they will indict it or they won't indict it. But to have his life in limbo, to have the complainant's life in limbo, and wanting the court to continue to have everybody in limbo, the court is not going to do it. He's been on GPS since 2023. There's not been any violations, and I think both parties can agree with me. To be on GPS and have 0 violations is next to impossible. In my time as a defense attorney, I'd only had 2 clients who have been able to do that. So here's the thing. You're on deferred adjudication.
Yes, sir.
If a motion to revoke is filed, you're looking at potentially 10 years in the prison. You are not allowed to contact the complainant. The court doesn't have anything before it to suggest to the court that you contacted the complainant, other than some double hearsay, maybe triple or quadruple hearsay. I have nothing of that nature. But what I can tell you is, if there is credible information that you've contacted the complainant or had third parties to contact the complainant, in case you don't know it, that would be a violation. So if some third party, you have them to contact the complainant on your behalf, it's a violation of your probation. Do you understand?
I understand.
All right, relationship is over. You understand that?
I understand that.
All right, is there anything else?
From the state.
All right, GPS will be removed. Continue what you're doing, and you can come back later once the time is appropriate for early termination.
Thank you, Judge.
Thank you.
You're welcome. Thank you.
Judge.
All right, let's head back to Michigan and Judge Simpson again.
Is that correct, Mr. Fulton, that you're waiving your right to a preliminary exam?
Yes, sir.
All right. I'll let you finish signing there, but there. You understand that where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes,
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, been found over to circuit court on all three.
Thank you, Your Honor. We acknowledge receipt of the information and we waive its reading on the record. My client was.
Bye, Constantino. Never mind.
Great to see you.
Yeah, always a pleasure. Go ahead. I'm sorry, Mr. Brown.
My client will stand mute.
Defendant every way former reading, standing mute, court will enter a not guilty plea as to all 3 counts. Pre-trial in this matter will be set for
June 10th at 1:30 p.m. with Judge.
I'm sorry, Judge.
Yes, sure.
June 10th, 2025, 1:30, Judge Conkey.
Thank you, Your Honor. May we address the issue of Your Honor, I've had a chance to submit a mitigation report to the prosecution. I've read it. At this time, we are asking that my client's bond be modified so that he can stay at the 2735 South Wagner Road address, Ann Arbor, Michigan. If the court feels that a tether would be appropriate, my client will be happy to do so. We feel that the circumstances of this case warrant release to that address. He is not a danger to the community at large. He will return to all future court dates.
Your Honor, Mr. Brown did provide me with a mitigation report with respect to this client. In reading that report, with some information provided, I would not have an objection, provided the defendant is on a tether, that he be released while this case is on.
Home confinement.
That would be my preference. I don't believe that he has a reason that would conflict with his life.
It's okay.
It's a defendant's bond at $30,000. Personal recognizance. Defendant may be released on a home confinement tether. That tether has to be in place prior to his release.
And which judge is this going in front of?
Good Kunky.
Okay.
Thank you.
Thank you very much.
Okay, so that one might have to, that's fine. Okay, so are they ready on the other? Court calls case first, Ammerman.
Morning, Your Honor. Alex Warren, Green on behalf of Ammerman. Your Honor, I reached out to Mr. Ammerman. We did not receive any correspondence in return. For the record, I'd ask for an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set at 10,000 cash surety.
Thank you, Your
That
Honor.
warrant will issue immediately. Court calls case People versus Douglas Hill.
Stephanie Cannon. On behalf of Mr. Hill.
Your name, sir?
Douglas Hill.
Thank you.
Your Honor, we are going to be asking for a brief adjournment on this matter. But with the adjournment, we'd also like to address bond.
Without objection, probable cause conference June 12, 2025, 9 a.m.
Your Honor, as
Do I have a
to
green sheet?
bond,
Do I have a green sheet?
I'm working on, Your Honor. I have a few of them in my hand. I'm so sorry. As to the bond, Your
I
Honor,
was gonna be adjourned, I see. No need to comment. Go ahead.
thank you, Your Honor. As, and my pen,
Oh, Cannon, really? It's just one of those days.
it just,
Thank
it went
you.
under the lectern, Your Honor. My pen went under the lectern. I'm so sorry. Here we go. As to Mr. Hill, there's the green sheet. Thank you. I'll get it eventually. As to bond, Your Honor, my client has a appointment on June 2nd with the IRS regarding a very serious matter. He is requesting a furlough for that day, just so he can meet with the IRS. He'll come directly back.
Taxes?
So yeah, so he's, this meeting was
You asked
set.
what it was about. And
Well,
he said taxes.
he said
Proof about
taxes.
it? No, don't worry about it. I don't even know why she asked that
Well,
question.
yes, Your Honor. So it is a tax matter. I didn't want to go too far into.
No, I don't.
Okay.
If he's got the appointment, I just need proof of the appointment. Maybe I'll consider
And
it.
we can do it in writing.
Yet you'd have to do something in writing regarding that.
Perfect. Your Honor, in addition to that, as you know, my client was, the last time he was up, the court did remand him because he was testing positive for substances that he should not be testing positive for. My client at that time was trying to get into a treatment program. Matter of fact, he came from, he was after court, he was supposed to go be scheduled to be screened. My client is asking if he can be released to inpatient treatment if the court would allow that.
For inpatient treatment, if you send me an order that's stipulated to, certainly I will sign it.
Perfect, Your Honor. Then I'll make it
I'm not
a,
going to object to release the inpatient.
perfect. Then, Your Honor, with that, I believe we are all set.
Thank you, Your Honor.
And I'm gonna,
Thank you.
Can I-
At this point, his bond will continue. And I'm not saying, so that we're clear, I'm not saying I grant the furlough, but I need to see information. Thank you. Really, Cannon. Did you get your pen?
thank you, Your Honor. Yes.
Court calls the case People versus Roderick Bates. So. The dish is ready. Who's the other one? Buckovich and Shitnausen? Okay. Your name, sir?
Roger Bates.
I'm sorry, Mike Gaddy, Assistant Public Defender for Mr. Bates.
What are we doing?
Your Honor, I'm asking the court for a brief adjournment to go over this matter some more with Mr. Bates and to go over more discovery. I will submit a green sheet immediately.
June 12, 2025, 9 a.m. bond continued.
Thank you.
Hold on 1 second. So you think they're ready on this? Let's see if we can get. Got other stuff to do today, I'm sure. Yeah. What? Which one are you on? Taylor Cruz. What about Mr. Buckovich? What are you ready on yours?
I don't think you have an AG.
Yeah, I can be ready.
You can be ready?
Yes.
Well, didn't sound real confident, so I'll let you wait. Court calls the case, People versus Clyde Moore Jr.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
And Assistant Public Defender Chinazi Carey, I can rule, Your Honor, on behalf of Mr. Clyde Moore Jr. Mr. Moore, if you're still there, could you please state your name for the record? Turn your camera on too.
I haven't. He's not there. No, what are you calling him?
Just wanted to shoot a text, Judge.
I sat there and asked, were we ready on the Attorney General cases? Because this is now, she had 5. This is now the 8th case I've called, some of them duplicates. So are you expecting, Ms. Eckenrudely, that I'm going to wait for him to respond to your text?
Absolutely not, Your
Thank you.
That's not my expectation at all.
He's not here. Clyde Moore. No response. Bench warrant will issue for defendant's failure to appear. How much is owing in child support?
No, Mr. Moore is the one who has paid in full, Judge. And
He's paid in full, but
yeah.
where is he?
He was on Zoom. I think he might have misunderstood us passing the matter and may have logged off.
This is the plea.
This is the plea. That is correct, Judge. I have the paperwork here.
You have the form,
I do.
but you don't have a client.
Yeah.
He needs to show up before I finish with the Attorney General cases, or I'm issuing a bench warrant, plea or no. And we'll have a captive audience. Court calls the case, People versus Rafael de la Cruz.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
On behalf of Ms. De La Cruz, Your Honor, can we please approach?
No, you don't need to approach. You're looking for an adjournment because the wrong time may have been sent to you. My staff has informed me they can't verify it certainly, but they think that the wrong time may have been sent to the defendant. So in that instance, I will adjourn it.
Thank you, Your Honor.
See, unlike some people in your office, I take responsibility for what we may do.
Every time I
June
take
12, 2025, 9 a.m.
What's the date, Your Honor? I'm sorry.
June 12th.
June 12th. Okay, thank you.
Thank you. Yeah. Court calls case, recalls case, People versus Foul Ali.
This is the public defender on behalf of Mr. Ali.
Assistant Attorney General Clarissa Williams on behalf of the people.
Mr. Ali, can you state your name, please?
Ali.
Thank you.
After speaking to my client, he will be waiving his preliminary exam. I have a signed preliminary examination form, which I signed with his permission, to pursue the AG's offer in circuit court.
Mr. Ali, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes, Your Honor.
All right. People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Beckett.
Yes, as to the arraignment, we will waive the formal reading of the complaint and my client be standing mute as to the charge.
Defendant never waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
July 17th at 1:30 p.m. with Judge Slay.
July 17, 2025, 1:30, Judge Slay.
And just to put on the record, my client just wanted to let the court know that he does currently reside in Colorado for his court date. I believe July 17th should be enough time, but he also is the sole caretaker of his 13-year-old child. So I believe July 17th should be enough time for him to figure out his court date.
All right, bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Let's switch it up and go back to Judge McNally for a little while.
Your record is not very good. Why are you texting? Why are you can't do that. You know you can't do that. Why are you doing that? I mean, I'm shocked that we don't have so many more accidents anymore. I'm gonna go out of my way and rationalize why I'm gonna do this, okay? But please don't do that. All right? We got each other? All right. To that charge of distracted driving, responsible or not responsible? Please accept it. $230 is your total. I'll dismiss the original charge. No more of that, okay? Thank you. Marine Shahzadi, 25B148614. Good morning, how are you? Good, your name? All right, you're going to plead to impeding, right?
Yes.
Responsible or not responsible to that? I'll accept the plea. 195, cash your end of the hall to your right. Good luck.
Can I pay that Monday?
Sure, June 2nd.
Thank you.
If you don't have the money, call the court. We'll go on Zoom, or you can walk in here on that date at 8:30 and I'll give you an extension, okay? Just don't ignore me. Patrick Sean Quinn, 25B147845. Good morning.
Good morning, Your Honor.
You're going to plead to impeding, right?
Excuse me?
You're going to plead to impeding traffic?
Yes, Your Honor.
All right, to that charge, responsible or not responsible?
Responsible.
I'll dismiss the failure to stop assured clear distance. $200 is your total. Cash your end all to your right. Good luck.
Thank you.
Brooks, Jila Bridget Brooks, 25F243698. Does Gabe have anything ready?
I called him and texted him, he didn't answer.
Good morning, your name?
Good morning. My name is J.Lo Brooks.
Give me 1 second if you would.
Yes, sir.
Hey, Roger, do any of these guys have pre-tried cases with any of these guys? Ask them I haven't had a file from you guys yet. Ask them to come in here with their files and their clients, and I'll get them started. Thank you very much. Okay, how are you?
I'm good this morning. How are you?
Good, your name?
J.Lo Brooks.
So you can accept responsibility to expired plate. Plate had been expired for 2 months. You have your registration now?
Yes, I do.
To that charge of expired plate, responsible or not responsible?
Responsible.
I'll accept the plea. Look, I'll cut it down a little bit, 115, but you gotta have a valid plate, okay?
Yes, sir.
Thank you.
Thank you.
Yes, you're into the hall to your right. Abdul Rahman Nasir Ahmed, 25 F243829. I need Ahmed in here too.
All right, well, things have gone a little quiet there. Let's go back to Judge Simpson.
Court calls the case, People versus Elton Bell.
People. Public Defender Kema Dadush on behalf of Mr. Bell. Please state your name for the record.
Elton Robert Bell.
Thank you.
Your Honor, we were going to be requesting a brief adjournment so Mr. Bell can come up with more restitution.
Okay, how far off is he? I mean, I don't want to.
I got $50. I got $50 right now.
Okay, a month would be good, Your Honor, but whatever your Honor thinks is best.
Whatever I think is best.
We can request all we want, but it's
That's true.
Your Honor.
You're absolutely
thinks
right.
it's best.
Am I here? I am. All right. Probable cause conference without objection. We adjourn July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you. Court calls case People versus Stephen Johnston.
Hey, Richard.
Okay, I'm gonna put a tether on him. Where's Bukovich? He has not been up here for any case I've called of his.
Yes. Sorry. Assistant Public Defender Nicholas Buckovich on behalf of Mr. Johnston.
Your name, sir?
Stephen Johnston, Your Honor.
Thank you. What are we doing?
We'll be requesting a brief adjournment to pursue some negotiations. He also has some matters in the circuit court that we want to possibly reconcile together.
No objection to the adjournment. I did want to approach regarding a bond concern with Mr. Buckovich and with Ms. Zenda, if you could, please.
With Ms. Zenda?
Yes.
Oh, dear God, come on.
Nick.
All right, since he's muted, let's go say good morning to Judge DeSanto, Judge Mom.
Can you unmute your device and state your name for the record, sir?
Craig Cunningham.
All right, today's date and time set for a probable cause conference. It's being conducted by Zoom. Mr. Dox, do you give Zoom consent for this hearing?
Yes, Your Honor.
And how are we proceeding?
Your Honor, we're going to ask for a brief adjournment a week regarding, I just received discovery, did speak with Madam Prosecutor regarding some issues. And then we'll be able to proceed from there next week.
Any objection from the people?
No objection, Your Honor. I just received his appearance today, so that's why discovery was not sent until I logged on to Zoom, but I'm fine to adjourn it.
Okay. Court will adjourn the probable cause conference to, let's see, what's a week from today? June 6th, right? Oh, I'm thinking I'm on 28 District Court time, June 5th. What, can you give me a time?
Yes, 9 a.m.
9 a.m. Court will adjourn. Go ahead.
I apologize. I'm unavailable next week. I can do June 9th, if that works for the court.
It has to be on a Thursday, so can you do June 12th?
I'm in trial. If we do June 5th, a Thursday, I can do like 8:30.
We can do 8:30.
We can do 8:30.
Okay, thank you. I apologize.
No worries, no need to apologize. The court will adjourn the probable cause conference to June 5th at 8:30 a.m. by Zoom. And Mr. Dux, do you waive your client's 14-day rule in light of the adjournment?
Yes, Your Honor. For good cause.
I'm sorry?
Yes, for good cause.
Yes, thank you. Okay, bond is continued. Anything else for this record?
No, Your Honor.
No, Judge.
This hearing is concluded.
I'm sorry, can you repeat what you said about bond?
I said bond is continued.
And Your Honor, if I may, can we order a DSU report for my client?
Yes, court will refer to pretrial services for a DSU report.
Thank you. Thank you for, we'll talk, Mr. Cunningham.
All right, thank you.
You're correct. It is a substitute judge. So earlier this morning, it looked like Judge DeSanto was on the bench, and then all of a sudden she left for quite some time, and now we have this other apparent person. But they definitely have audio issues too this morning, quite crispy. So let's switch gears and let's go to Jefferson County Court at Law number 2, and we'll say good morning to Judge Terrence Holmes.
Via Zoom, please state your name for the record, Mr. Igno.
By your attorney, Nathan Reynolds. Attorney Reynolds, how are you doing?
Doing well, Judge. Thank you.
And Mr. Reynolds, do you waive a record in Ms. Hessel's case?
So wait.
State is represented in this case by Attorney Shane Hilton. Attorney Hilton, how are you doing?
I'm good, Your Honor. Thank you.
You are. Now, Ms. Hessel, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Francis Hessel, on or about August 19th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of theft of property, which was greater than or equal to $750, but less than $2,500. Ms. Hessel, do you understand what you have been charged with?
Yes, sir.
To this charge, Ms. Hessel, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Ms. Hessel, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document was filed by the court. And in this document, Ms. Hessel, do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials FH on a line next to a box that's checked guilty. You place your initials on this document.
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Ms. Hessel, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Hessel, are you a citizen of the United States?
Yes, sir.
State,
offers State Exhibit 1, Your Honor.
any objections?
No objection, States 1.
No objection, states exhibit number 1 will be admitted. Mr. Reynolds, you've advised and counseled Ms. Hessel. Is there any evidence that she is currently mentally incompetent to stand trial?
None to my knowledge. Yes.
And Ms. Hessel, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied? Excuse me, Mr. Reynolds has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Hetzel, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask for 9 days in the county jail with credit for time served of 9 days. And we'd ask that the court costs in this matter be taxed and retired.
Okay, Ms. Hetzel, the state is offering that you serve 9 days in Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail because you've already served 9 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Hetzel, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Sir.
Ms. Hetzel, I'll follow the plea bargain agreement that you have entered into with the court. Now, Ms. Hetzel, if you do not have anything else holding you in jail, you should be getting out of jail today. Now, Ms. Hetzel, please stand next to the bailiff and follow her directions. Once you finish following her directions, you can follow the bailiff. And you have a blessed day.
Thank you.
You're welcome. Okay, let's see. We're gonna call.
All right, lots of fits and starts across the various courtrooms today. Very sporadic. There's a lot of business going on, but lots of starts and stops. Let's go back to Judge Simpson.
And what she just did? You did? You did that?
Just go with the flow.
So she thinks she's all grown up now. Is that it? It's like between last week and this week that Tiger earned all those stripes. Okay.
Your Honor, we are requesting, I'm sorry.
She just doesn't care. She doesn't care that I've not done anything. Haven't given her permission. She's just gonna go. Don't worry about it. You're okay. It's her. I'm having issues. I should make her do it all over again. That's what I used to do in the old days. But I'm a much nicer person now. I want so much to deny him. But I won't. Permission to practice is granted.
Thank you, Your Honor. I appreciate it so much. Your Honor, we are requesting an adjournment in Ms. Brandt's case. We are still waiting on some video and a 911 call discovery, so.
Conference will be adjourned June 12, 2025, 9 a.m. Bond will continue. Thank you, ma'am.
Thank you so much, Your Honor.
Court calls case, People versus Chad Jones.
That's for the people, Your Honor.
Herma Dadish on behalf of Mr.
Chad Jones. Thank you.
Your Honor, we are going to be requesting an adjournment. He has 2 other PCCs up next week, where the bond, he was up last week.
Right.
We had adjourned those to next week. So I was going to adjourn to resolve everything together next week.
Oh, okay. So he was up. I adjourned those 2 weeks out. Basically, so they landed next week.
Right, and
And
yeah,
then there's
do it.
this one.
Mhm.
All right.
And also, we just got discovery on this case, so we need time to review it as well.
So everything right now is set for the 5th or the 12th for him?
It should be the 5th.
The 5th?
Yes, Your Honor.
Okay. And I'll adjourn this probable cause here to June 5th, 2025, 9 a.m. Get all these cases together. Bond will continue. All right. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Grace Brenner.
People, Your Honor. Assistant Public Defender Hannah Apple appearing on behalf of Grace Brenner. Will you state your name for the record?
Hello again, Your Honor. My name is Grace.
Thank you.
And Your Honor, we are
I
asking,
couldn't hear it.
she's fully capable. There's no reason, other than Ms. Brenner and I have been working together for a little while. No,
Kara wasn't supposed to do it?
no,
Oh,
I only have 2. She has
she was
the,
trying-
she has the other 10.
I thought she was trying to be late.
Yep.
Okay.
No, no, no.
Okay.
I just took 2.
All right.
The rest are hers. Your Honor, we're asking for an adjournment. There's some additional discovery investigation that we are doing on this
That's
matter.
trying to do on this.
Yeah.
Will 2 weeks be enough for you?
Um,
Did you need more time than that? I know you're trying
it's
to.
2 weeks enough, Ms. Brenner, or do you need for the phone situation or would,
My apologies.
sorry, go ahead.
I believe 2 weeks should be enough.
Okay, so
Yes.
why don't I do this? Let me give a little bit more time. I'll just go to the 17th. That's a Tuesday.
Okay.
June 17th, 2025, 9 a.m. Bond will continue. Okay, thank you, ma'am.
Thank you, Your Honor.
Case of the people versus Bruce Pickens.
Andrew Childers appearing on behalf of people.
Michael Getty, Assistant Public Defender on behalf of Mr. Pickens. Mr. Pickens, state your name.
Bruce Pickens. Thank you.
Your Honor, I'd ask the court to set these matters for exam.
For exam.
Yes, Judge.
All discoveries complete on this?
Yes, Judge, I believe so.
People have witnesses available to 10?
That's fine.
Preliminary examination in these matters will be set in person, June 10th, 2025, 9 a.m. before Judge Valvo.
Thank you,
Bond
Judge.
will continue in these matters.
Thank you, Judge.
Let's call the case of people versus Frank Clark.
Michael Getty, Assistant Public Defender on behalf of Mr. Clark, Your Honor.
Mr. Clark, you'll have to unmute and turn your camera on. State your name.
Frank Clark.
All right, what are we doing?
Your Honor, I have had a chance to discuss this matter with the assistant prosecutor. I do believe we have a resolution. I'll need to go over that with Mr. Clark, and we'll need to do a plea form. I have submitted a adjournment request, but I think we'll be able to move this file next at the next.
I have a green sheet.
I did submit a green sheet.
June 12th, 2025, 9 a.m.
Thank you, Your Honor.
Oh, you have a bunch of them. Okay, that's fine. On continue.
Let's move from 14A to 14B and see what's going on with Judge Washington.
And enroll within 24 hours of this sentencing, as long as he's able to get out. Is he being held on those other cases?
He is, Your Honor, currently. One of the cases has, it looks like a 50,000. I don't know if it's 10% or cash or surety.
All right. And then there is no use or possession of alcohol, marijuana, illegal drugs, firearm components, ammunition, or other dangerous weapons. Once you're out, you'll need to drug and alcohol test 3 times per month. And you need to attend NA meetings 2 times per week and provide proof of that to the probation agent and obtain a sponsor within 60 days. I'll see you back in 90 days on August the 28th, 2025. At that time, I'll see where things are, and maybe you'll know what's going on with your other cases, and that'll be at 10 a.m. If his resolution looks very different and this is not a real opportunity for him in the other cases, then we'll handle that at the review and do something different. Okay, Mr. Gatlin?
Yeah, I just got a question. You saying you're sentencing me to a year in the county and then
No, no, sir, you're not sentenced to a year. The rest of your time is suspended. As long as you do what you're supposed to do, you wouldn't have to do any more jail time on this case after today. So we're not holding you.
Thanks, Sharon.
You're welcome, sir.
Thank you. And God bless y'all.
Thank you. It's the one you want me to call next, then? Okay. All right. The court will call the matter of the state of Michigan versus Natasha Lawson, case number 24 FB 1442.
Tiffany Woods for the people.
Assistant Plug Defender Davia Liba for Ms. Lawson. Ms. Lawson, could you state your name, ma'am?
Natasha Lawson.
Thank you. I think that this matter got placed on today's docket erroneously, and notices went out erroneously. It was supposed to be set for sentencing for June 12th. And so I don't think there's a report that's been done. Is that correct?
That is correct, Your Honor. I did have a discussion with Ms. Lawson about the outcome of her recovery court screening, but I haven't received any kind of report.
And what was the outcome?
Ms. Lawson told me that she has indicated she was accepted into RC. However, she is not interested in that program due to her long-term sobriety and recent completion of inpatient treatment.
Ms. Woods, anything you have to say about this?
I mean, I'm surprised that, I mean,
Why was the case reduced? 1 second. I'm looking for the plea form. Because if that was a part of her plea deal, then she can just go back to felony court.
As far as I know, that's not what the deal was.
And I'm checking my notes, Your Honor. I don't believe so, but I am checking my notes from when it was in felony status.
and my notes just say she pled to count 2 OWI CS second and added count 4 CS use, and then counts 1 and 3 were dismissed. And I don't have any other notes in regards.
Can I see counsel in a breakout room?
Okay, well, she's going to go to a breakout room. We're going to do something a little bit different, and I need to go there just because of the name of the city. We are going to go to Battleground, Washington. This is Judge Andrew Wheeler. This will be our first time visiting with him, but the name alone, Battleground and court, it just kind of works. So let's see what's going on with them. Battleground, Washington.
To the podium in front of me. I'm going to discuss the charge that brings you in front of the court. I'm also going to talk to you today about your options. One of the things that I cannot do today is provide you legal advice. So if you're unsure how you want to proceed or you need some additional time, I'm fine with having folks have a seat for some additional time to consider their options. You are going to see at the television above you or over to my right, we do also have folks that are appearing from the Clark County Jail. I have a more limited time with the folks in custody, so I have to oftentimes call those matters out of order. I am not intending to keep anyone here longer than they have to be, but simply I have less time with the folks in custody. I have Robert Dougson in the courtroom. Come on up here, podium, sir. If I could have you just state your name and date of birth, please, for the record.
Robert Dougson, 10/26/1978.
Good morning. So, Mr. Dougson, you are before the court on two charges, sir. The first is a simple misdemeanor called driving while suspended in the 3rd degree. That is subject to 90 days in jail and a $1,000 fine. The second charge is a gross misdemeanor called operating a motor vehicle without an interlock device. That is subject to 364 days in jail and a $5,000 fine. I did review the associated police reports with both charges. I did find what is called probable cause. Because these are criminal charges, Mr. Dougson, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today for a court-appointed attorney?
I was hoping maybe that with my paperwork I brought you for everything that we could maybe get it squared up today.
We're not doing any kind of mini trials today here, so certainly what we can do is enter a not guilty plea, and I can schedule a date for you to talk to the city attorney. They're the only ones that can change or amend your charge. The only thing I can do is find you guilty or not guilty, but again, we're not doing a trial today.
All right, then I'll.
Sounds good. We'll enter a not guilty plea to preserve all of your rights and keep all of your options open. There's also nothing I'm doing today that would prevent you from getting an attorney later on if you chose to, okay? We're going to schedule 2 future court dates. The first is what is called a pro se pretrial conference. This is all going to be on the paperwork I'm going to give you. The first date is going to be on June 12th, 2025 at 2 p.m. You can be in person that day or on Zoom, but you do need to be present. The matter does not resolve that day. We're going to schedule a readiness hearing for the 10th of July, 2025. That is also at 2 p.m. While your case is pending, you are to violate no laws, appear at mandatory court dates, notify the court of any change of address or phone number. You're not to drive without a valid license and insurance. I'm releasing you at this time on your recognizance. So the city attorney's office can be in touch with you. Is there a phone number I can write on the form?
Yeah, 509-655.
So Mr. Dougson, we're going to get you some documents at that very far desk over there by the door. And once you have your documents, you'll also get some contact information from the city attorney's office. You are free to go. Thank you. Very far desk by the door. Timothy Walsh. If you could state your name and date of birth, please, for the record.
Timothy Walsh, November 16th, 1986.
Mr. Walsh, you're before the court on 2 cases that you were on warrant status for. The first is vehicle prowling in the 2nd degree. The second is theft in the 3rd degree. These charges are both from November of 2024. It looks like you have been on warrant status with this court since March. You had previously been assigned a court-appointed attorney. Would you like a court-appointed attorney reassigned to your case?
Yes, Your Honor.
Okay. I'm going to reassign Greg Cheney. I know that Ms. Ward was originally your attorney. She no longer has a contract with the court. She has a new job. So we're going to assign Mr. Cheney. We're going to enter not guilty pleas to both of the pending charges. I'm going to assign 2 future court dates, sir. The first is what's called an attorney pretrial date. That's a date only for Mr. Cheney. That is going to be on the 11th of June, 2025. Your next mandatory court date, sir, is going to be on the 17th of July, 2025. That's going to be at 10 a.m. You can be in person that day or on Zoom, but you do need to be present. Your release conditions, sir, are to violate no laws, appear at all mandatory court dates, not to consume or possess any alcohol, non-prescribed drugs, or controlled substances while your case is pending, to have no contact with Matthew McConnell. I'm going to release you on this at this time on your recognizance, sir. If you don't make your next court appearance, though, you're going to be in the Clark County Jail the next time you see me. So you need to come to court. Do you understand?
Yes, Your Honor.
We're going to get you some paperwork. We're also going to allow you to connect with Mr. Cheney this morning over at the desk by the door. Once you have your documents, you are free to go. Yes.
Thank you, Your Honor.
What level of SR did they have him on, Ms. Travers? Yeah, could you just amend that to admin? Admin is just going to be 2 phone check-ins a month, sir, just to make sure you're making your court dates, okay? Thank you for bringing that up, Ms. Travers. Apologize for not catching it.
Your Honor, jail boot being a certain level.
Mr. Newell, can you hear the court, sir? I could have you, sir, state your name and date of birth, please, for the record.
Richard Donald Newell, 22387.
Mr. Newell, you are making a warrant cancellation today on a charge from June 25th, 2024 of controlled substance knowing possession. That's a gross misdemeanor subject to 180 days in jail and a $1,000 fine. Your attorney, Mr. Cheney, is with us here in the courtroom. Go ahead, Mr. Cheney.
Thank you, Your Honor. Entering a not guilty plea, waive formal reading of the charges. I would note for the court that it appears that he has a first appearance on several felony matters this afternoon. No bail has been set on those, but I would presume that would likely occur this afternoon at the first appearance. We would ask the court to set this matter over 2 weeks to see whether or not he is still being held or what the status of the felony matters is, so we can get a better sense of what might be happening in those cases. So just 2 weeks set over at this point.
Ms. Carmy, did you want to release our hold was the amount, our bail amount in our case was in the amount of $1,100.
Yes, we can release our hold and set out 2 weeks, Your Honor.
All right, battleground hold is going to be released today. So Mr. Newell, you're not going to be held on our case. You may be held on cases that you're seen on this afternoon. If you are not, we're going to be scheduling a court date regardless in the next 2 weeks. So your next time before this court, sir, is going to be on the 12th of June, 2025. If you're out of custody, that's at 10 a.m. If you are in custody, they will bring you over when there is availability and so forth in the jail booths. Again, I am releasing you on this matter. I'm releasing you on this matter on your recognizance. Conditions of no consumption or possession of alcohol or non-prescribed drugs. Violate no laws, appear at all mandatory court dates, and notify the court of any change of address or phone number. We're going to get you some documents, sir, over at the jail, and that concludes your hearing today. Do you have any questions?
No, thank you.
Thank you, sir. Okay, and Mr. Sowards, are we ready on Mr. Martinez Miza?
Yes,
Mr. Martinez Miza, can I have you state your name and date of birth for the record, please, sir?
Señor Martínez Misa, ¿usted me hace el favor de decir su nombre y su fecha de nacimiento para que conste en las actas, señor?
Sí, es Eduardo Alejandro Martínez Misa y mi fecha de nacimiento es el 1 de septiembre del año 1998.
Yeah, my name is Eduardo Alejandro Martínez Misa, and my date of birth is September 1st, 1998.
Mr. Martinez Misa, you are communicating to the court through a court certified interpreter, Ms. Wells. Are you
Señor
able,
Martín. Oh, go ahead, Your Honor. I'm sorry.
all right, are you able to understand the translation from English into Spanish?
Señor Martínez Misa, usted se está comunicando con el tribunal a través de una intérprete acreditada del tribunal, la señora Wells. ¿Puede usted entender la traducción del inglés al español?
Sí, muchas gracias.
Yes, thank you very much.
Your attorney, Mr. Soward, sir, is in the courtroom. Mr.
So-
Soward, go ahead when you're ready.
Oh, I'm sorry. Su abogado, el señor Sauer, señor, se encuentra en la sala del tribunal. Señor Sauer, adelante cuando usted esté listo.
Your Honor, this matter is from a December conviction here in Battleground.
Su señoría, este caso es de un fallo condenatorio de diciembre aquí en Battleground.
Mr. Martinez Mesa was ordered to obtain a mental health evaluation and proof of treatment.
Al señor Martínez Visa se le había ordenado obtener una evaluación psicológica y una prueba de las terapias.
The file shows a evaluation in December of last year.
Se ve en el expediente una evaluación en diciembre del año pasado.
The file does not have proof of follow-up treatment.
El expediente no muestra una prueba de tratamiento de seguimiento.
Mr. Martinez Mesa informs me that he has been treating with the Atlas program in Portland.
El señor Martínez Misa me informa que él ha estado recibiendo tratamiento con el programa de Atlas en Portland.
However, he missed his March 20th review date here in Battleground.
Sin embargo, él faltó a su fecha de revisión del 20 de marzo aquí en Battleground.
He is requesting that the court release him so that he can obtain those records, and I've advised him that he needs to get those to Battleground as soon as possible.
Él está pidiendo que el tribunal lo deje en libertad para que él pueda obtener esos registros. Y yo le informé de que él necesita conseguir esos, necesita entregar esos a Battleground lo más pronto que sea posible.
And Your Honor, the difficulty with that request is that he is being held on the felony matters, a combined 20,000 bail.
Y su señoría, la dificultad en cuanto a esa petición es que a él lo tienen retenido por casos de delitos graves, una fianza en combinada de 20,000.
So while we don't object to releasing our hold, which actually I think was already released at district court, he will still be held.
Entonces, aunque nosotros no nos oponemos a quitarle nuestra orden de retención, a la cual yo creo que ya le fue quitada en el Tribunal de Distrito, aún va a quedarse retenido.
His next appearance in the felony matter is July 3rd at 9 a.m.
Su próxima comparecencia en el asunto del delito grave es el 3 de julio a las 9 de la mañana.
The referenced felony matters, Ms. Carmi, because I do not have a DCH, are they pre-conviction on this or post-conviction on our matter?
Los asuntos mencionados de delitos graves, señorita Carmi, porque yo no tengo un DCH, ¿ellos son precondenatorios en cuanto a esto o postcondenatorios a nuestro caso?
They occurred prior to our offense.
Ocurrieron antes de nuestro delito.
If it has not been already, I will release the battleground hold.
Si todavía no se ha hecho, yo quitaré a la orden de retención de Battleground.
I believe July 10th is a date where we have Mr. Sowers in Battleground.
July 3rd, 17th, and 31st.
Yo creo que el 10 de julio es una fecha cuando tenemos al señor Sowards en Battleground. El 3, 17 y 31 de julio.
This matter will be set over to July 17th, 2025 at 8:30 a.m.
Se aplazará este caso al 17 de julio del 2025 a las 8:30 de la mañana.
Mr. Martinez Misa, if you are released on your felony matters, you are to be in person in Battleground on July 17th.
Señor Martínez Misa, si usted es liberado por sus casos de delitos graves, deberá presentarse a Battleground personalmente el 17 de julio.
If you are in custody, you'll be brought over to appear as you have today on the camera system.
Si usted está recluido, entonces usted será puesto así por video, tal como lo han hecho hoy en el sistema de cámaras.
Do you have any questions, sir, regarding the proceeding today?
¿Usted tiene algún tipo de pregunta, señor, referente a la actuación del día de hoy?
No, su señoría, muchas gracias.
No, Your Honor. Thank you very much.
Okay, thank you. That concludes your hearing. Thank you, Ms. Wells.
Bueno, a usted. Con eso se concluyó su audiencia. Gracias, señora Wells. You're welcome, Your Honor. De nada, su señoría.
May I ask, have I?
So let's hop over to Judge Boyd. I put us in the Wayback Machine just a little bit because while this was going on, I caught her, it looked like starting to chew somebody out. So let's see what this was all about.
Okay. All right, Kimberly Essex.
I can't hear, ma'am.
All right, are you able to hear now?
Yes, ma'am.
All right, so today is your plea deadline date.
Oh, okay. What do you want me to do?
Well, I mean, do you want a jury trial or have you reached an agreement with the state?
I haven't reached an agreement with the state.
All right, counsel, how long do you think this jury trial will last?
Could be a few days. I'm not positive.
Okay, sorry.
But what I was Hunter is the prosecutor on this, and he'll be back next week. The prosecutor was here, says she does not have the room to negotiate. And Miss Essex was just indicted on the 8th of April this year, and I was appointed on the 19th.
Yes.
I'm just requesting, waiting for jury, plea deadline date for Monday so I can talk with her and Hunter. See if there's any chance to negotiate, an agreement.
All right. Ms. Ferguson, on this case, put it for Monday. There'll be no further extensions of plea deadline dates.
Is it an attorney visit?
I
Yeah, it's an
appreciate
attorney
that.
visit.
Thank you.
With Garcia? It says Matthew Allen. Oh, we'll slide with it.
All right, Miss Essex?
Yes, ma'am.
All right, so let me just tell you something. When you
Okay,
are
sure.
when you are ordered to be in court, you're supposed to be in court. There will be none of this, oh, I refuse to come, because if you refuse to come, what's going to end up happening is the deputies are going to bring you anyway. And who do you think is going to end that argument when I tell the deputies to bring you? You're going to lose that argument. So this whole childish thing where people are not coming because you have something better to do, or you just refuse to come, you will be brought over, and you're going to lose that argument when you get into an argument with the deputy about whether you're coming to court or not. Do you understand?
I understand, Your Honor. I thought it was June 29th.
Here's the thing.
That's it.
This is why people are at the Bexar County Jail in custody, because you have someone in authority telling you that you're scheduled to go to court today, and your thing is, no, I'm not coming. So I'm telling you, the next time a deputy tells you that you have court, you better come. Do you understand?
I understand, Your Honor.
All right, thank you.
Thank you.
Thank you, Judge.
Okay, now we know what that was all about. Like I said, I just caught a glimpse of that while the other hearing was going on and was curious. She never disappoints. What caught my attention, though, was the fact that she was calling in from inside the jail, which isn't normally something we see in Judge Boyd's court. So that definitely caught my eye. Let's go back to Battleground to finish out the day.
Okay. Okay. Brian Archer in the courtroom. Would you come up here to the podium, sir? Good morning, Ms. Connor.
Good morning.
Morning, Your Honor.
If I could have you state your name and date of birth, please, for the record, sir.
It's Brian Archer, 5/5/1977.
Okay. Mr. Archer, you're making a first appearance arraignment on a charge of a protection order violation. That charge, sir, is a gross misdemeanor. It is subject to 364 days in jail and a $5,000 fine. I have reviewed the associated police reports with the case. I have found what is called probable cause. You have retained, it looks like, attorney Ms. Nigro on the case. Mr. Schinnebeck is present for Ms. Nigro today. Mr. Schinnebeck, how is Mr. Archer asking to proceed?
Yes, Your Honor. At this time, we would waive a formal reading of the charges and enter a not guilty plea.
Not guilty plea is received. Mr. Archer, I'm going to be assigning to start with 2 future court dates. The first is an attorney pretrial date. That is going to be on the 11th of June, 2025. That's a date just for Ms. Nigro. It's not a required court date for you. Your next mandatory court date, sir, is going to be on the 10th of July, 2025. That's going to be at 1:30 in the afternoon. You can be in person that day or on Zoom, but you do need to be present for the court proceeding. What's going to happen now, sir, is I'm briefly going to hear from the city attorney, Ms. Carmi, regarding conditions of release. I'll then hear from attorney Schinnebeck regarding release conditions. Go ahead, Ms. Carmi.
Yes, Your Honor. The felony case from February of 2025 that resulted in the no contact order is still valid. And so we are asking that as a condition of this case, he continue to abide by the no contact order under the Superior Court cause number. He is under pretrial conditions in the felony case that is still pending. We're not asking for anything additional in our matter.
Mr. Schinnebeck, I'm assuming no objections to any of that.
Correct, Your Honor. No objection.
All right, so Mr. Archer, the following are going to be your conditions of release, sir. You are to violate no laws and appear at all mandatory court dates. You are to notify the court of any change of address or phone number. You are to abide by the existing Superior Court no contact order. On this matter, I am releasing you on your recognizance. We're going to be providing you, sir, some documentation at that very far desk by the door. And once you have your paperwork, you are free to go.
Thank you, Your Honor.
You.
Thank you, Your Honor.
Thank you for your assistance today, Ms. Connor.
Thank you so much. You're welcome.
Ian Raleigh. Good morning, sir.
Morning.
Can you state your name and date of birth, please, for the record?
Ian Raleigh, 11/19/01.
Mr. Raleigh, you're making a first appearance arraignment on a charge of DUI. DUI in the state of Washington is a gross misdemeanor. It's subject to 364 days in jail and a $5,000 fine. It's also a charge if you are convicted of it that carries a license suspension, a requirement for high-risk insurance, interlock, mandatory jail time, those sorts of things. I did review the associated police reports with the case. I did find what is called probable cause. Because this is a criminal charge, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today for a court-appointed attorney?
Yes, please.
Okay, I'm going to ask you some questions about your income to see if you qualify. You receive any manner of state assistance at all?
No, sir.
Are you employed right now?
Yeah.
Can you estimate about how much you're earning per month after taxes?
Roughly 3,500.
Okay. How many folks do you support on that income?
None.
Okay. You are above the guidelines for a court-appointed attorney. So what we're going to do today to preserve all of your rights and keep all of your options open is to enter a plea of not guilty. I'm going to schedule a time for you to talk to the city attorney. There's also nothing that I'm doing that prevents you from hiring an attorney if you chose to, okay?
Okay.
So I'm going to schedule 2 future court dates. The first is what is called a pro se pretrial date. That is going to be on the 12th of June, 2025 at 2 p.m. You can be in person that day, Zoom, but you do need to be present. The matter does not resolve that day. We're going to schedule a readiness hearing for the 10th of July, 2025, also at 2 p.m. Those are both mandatory court dates. Your release conditions, sir, to violate no laws appear at all mandatory court dates, to notify the court of any change of address or phone number. You are not to consume or possess any alcohol or non-prescribed drugs. You are not to drive without a valid license and insurance, and I am releasing you on your recognizance. So the city attorney's office could be in touch with you. Is there a phone number I could write on the form here, sir?
My personal cell is 360-688.
So Mr. Raleigh, over at that very far desk by the door, we're going to be providing you some paperwork. We're also going to do some contact information for the city attorney's office. Once you have your documents, you are free to go. Thank you.
Okie dokie, this seems like a good place to leave it for today. I hope you all had fun. I know I did. I hustled today. It was, I don't know if it showed in the live stream itself, but it was hard to maintain this today because so many of the courts that I was looking at, they were in and out of things constantly. So I'd get something like queued up and ready to show you, and then just as quick as I've got it queued up, they're moving on to something else or taking a break or whatever. So it's a little hectic today, but hopefully y'all had fun. I'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Members a half an hour early. If you are a channel member, reminder, you voted for an AMA tomorrow, so bring your questions to that pre-show. If you want to join us on the pre-show, you do need to be a channel member. It is incredibly inexpensive, and that's only one of the benefits you get. I didn't pin it today, did I? Normally I have a pinned chat with that link in it. Doesn't matter. Go to the channel page. You can join there. But again, go make yourselves a great day today. Have a happy Thursday. We'll see you tomorrow, which is Friday. The days just continue to slide by so fast. Appreciate all of you. We'll see you tomorrow. Take care. God bless.